Good evening. I'm Laura Harmon. I'm an assistant general counsel with the Illinois Farm Bureau, and I spent quite a bit of time traveling around the state, doing landowner meetings. Similar to this, in other parts of the state, we have companies that want to put in transmission lines or pipelines and take our members' property. And it goes through a different process that's before the ICC. So, there's some similar issues, but this particular type of proceeding is different. And it's the first, really the first highway, in recent history that we've had, impacting our landowners. I know several years ago we had I-355 and 59 expansion, but this is the first major toll road project that, the only one that we're dealing with in the state right now. Hopefully, did everybody get a copy of the landowners guide? Okay. This is actually IDOT's own document, and I have to tell you, it does a really great job of taking legalese and explaining it in plain language. So, I'm not sure how many people are going to have the opportunity to read this while you're waiting, but please take the time to read this. It does a good job of explaining the eminent domain process. But what I really want to encourage you to do is, before you ever get to that process, it's a lengthy process, and nobody wants to go through that. Private companies don't want to go through it. The quick take process. The state really doesn't want to go through that. And I think that when you look at the steps that they just went through, to me the key is step 2, before you even get to the negotiation process, and that's when the appraiser comes out. I know many of you probably don't want to meet with their appraiser, but I think it's probably in your best interest to do that. If you've got a farm manager, then maybe you want your farm manager to meet with them. But here's why. The state has to compensate you for the fair market value of your land, and they also have to compensate you for damages. And this is a unique situation because we're farmers, and the state and the appraiser doesn't really know what farming means. So in order for you to get an accurate appraisal, and I think get the best appraisal, you need to explain to the appraiser what you do. Some of you may have livestock operations. That brings a whole other, can of worms that the state has to deal with, and they have to compensate you for that. And then appraiser is not going to, probably going to know nothing about livestock operations. So that's just an example. So I really am trying to impress upon you the importance. It's probably in your best interest to sit down with the appraiser and explain to them what it is that you do. This isn't like a situation where a company wants to put in a pipeline or a transmission line, and that's going to have different impacts on your property. But putting a highway either next to your property or in the middle of your property is going to impact your farming operations after the highway is put in. You need to probably talk to your aerial applicator. How many people do aerial spraying? You need to talk to the aerial applicator and find out if this highway is going to impact how they apply on your property. If they're prohibited from doing it, that's a damage to you. It may be more expensive to apply. Your cost may go up afterwards. These are all things that the appraiser needs to know, so that's built into your appraisal. So I want you to start thinking about what damages this is going to cause, not just to the fair market value of your farm or the fair market value of it after the highway put in, because those are all obvious. So I want you to kind of drill down and think about those issues. Does anyone have irrigation? Okay, well that's good. But if you had an irrigation system, this would impact that. Does anyone, for livestock, may impact your, especially depending on where they locate it, your actual livestock operation. So you need to sit down with them and explain, well, or if you had an expansion, and you were seeking to expand your livestock operations on your property, that's all an element of damage that the appraiser needs to know about. So a few things that I think that's really why it's really important for you to sit down with the appraiser and talk to them about your daily farming operations and how this is going to impact them. That way, they can come up with a more accurate appraisal. Without having purchased it?
Based on the zoning ordinance in your area.
What's that got to do? I still got to live with it. But if you live in the city or you're next to you is next.
Which your town,
State getting all the money.
zoning
Thought they were
ordinance,
broke.
distance from roadway or frontage setbacks and things like that, that's the way that comes out.
Right now it's 12 feet from the house.
That's the zoning.
No, that's where your road, for where it's supposed to go. 12 feet from
We haven't determined it.
You guys had it at the last meeting.
Well, let me
You
address
brought it
that.
up in the meeting.
Right. That's a conceptual 400 foot that was used to identify the current impacts. What we're gonna be doing during tier 2 is adjusting where that 400 foot goes to see where we can route it the best with the least amount of impacts.
Yeah, because it makes sense to take the shed behind my house and leave
That's what we're gonna be doing during the next phase of this project, is to actually go on the ground, survey what's actually out there and see what we need to avoid.
The other question I have is, if say Walmart is going to come in and build, they don't pay fair market farmland property value. They pay commercial price. And that's what Farm Bureau says it should be. The last law meeting I went to said it should be. It should not be farm value price, period. I'm sure everyone in here feels the same way.
Yeah, and that's a lot, it's basically has,
What is the question? Okay, what question? Yeah.
Should we, yeah.
the question was, or the comment was, in terms of being paid, he said Walmart, used that as an example, pays for commercial use. And under the law, you're compensated based upon, and it has to do what your land is zoned as. So this is the land that they're taking, and in this case, it's
You're paying one right now, but you guys are going to use it for a tollway, which is commercial use.
Under the law, they have to compensate you for what it's zoned as. So, and the highest use under that zone. So, I mean, this is definitely, this issue has come up before, and a pipeline case actually involving Enbridge, and that similar argument was made because it was farmland, and the farmers wanted to be paid as if it were development. And in that case, they were paid as farmland. So, you know, these are certainly arguments that you can make, and they've been made before, but in a ICC proceeding, that argument was rejected.
Right, where B4 or B3 ends, that's where Ridgeport development is. That was farmland, that was rated commercial. And it will only, Wilmington annexed it, but the farmland was already purchased by Ridgeport. And it was not farmland value. It was considered.
And in that situation, and again, it depends on the facts, but if you can establish that it has a different zoning, or there were plans for it to be zoned differently, then you may have an argument. But again, they're going to go by, their offer's going to be based upon what it's zoned as. So, but
I want to go back to the original statement. So the county zoning setback requirements dictate whether or not they would be purchasing your property. Say if the highway was 110 feet from the side of your house, and the county zoning requirement says 75 feet, they would not be purchasing the house in that instance. Is that what we're saying? But if the side setback is 75 feet and the house is 74 feet from this final determination, they would be purchasing. Is that what you're saying the criteria is? Well, you mentioned the township, but in Will County, if I understand it right, the county sets zoning setbacks, front yard setback, all those different parameters, not the township.
Please don't kill the messenger. There's a statute that covers when the department, when a property owner can insist for a highway on a new location like this, when the entire property for residents is desired to be bought. It's broken down into a couple different categories. And there's strict restrictions on that. The first one and I'm calling these homesteads, just as a general phrase, is if the property is a small property, 1 acre or less, and it conforms with all current zoning ordinances, setbacks, and by any partial right-of-way acquisition, we now put that property out of conformance, that property owner can demand that the department buy the entire property. So there's some restrictions there, so 1 acre or less. The other opportunity, and it's a tight number, it doesn't have anything to do with the zoning or the setbacks or the size of the property. It talks about if the proposed right-of-way line is 10 feet or less is the restriction. So,
Are you gonna live 10 feet or less or more away from the road?
I didn't write the law.
Common sense said no.
I know, and one of the discussions I was having here in some of the meetings that are going to be upcoming when they're trying to further define the alignment, if you're close to the B3 or corridor and you have that concern, you can make the comment that you don't want to be 10 feet or 50 feet or 100 feet from the corridor. If it's going to be that close, maybe your preference is you prefer that they just buy your property, put the corridor on the house. Those are comments that the department can't consider when trying to define the alignment.
Can you give us the name and number of that statute and
Yes.
where we can find it? So we can read it?
It's 605 of ILCS, that's the Illinois compiled statutes, 5/4-501.